to the Committee on Justice and the Committee on Social Affairs. A joint submission on the application of LVU, rule of law, and the best interests of the child. To the members of the Committee on Justice and the Committee on Social Affairs. I am addressing both committees simultaneously because the issues raised concern both legal safeguards and social implementation. The LVU operates at the intersection of law and social policy. When the system fails, responsibility cannot be deflected or reassigned. It is a shared responsibility. This submission does not challenge the purpose of the law itself. It challenges how the law is currently applied in practice in ways that conflict with the principles of the rule of law, the Convention on the Rights of the Child, and the clear intent of the legislator. When the state forcibly removes a child, there is no undo button. When the state makes a mistake in such decisions, the damage caused cannot be repaired afterward. That is precisely why standards of evidence, proportionality, legal certainty, and accountability must be higher here than in any other area. Why this submission concerns both committees. To the Committee on Justice. The failures described involve the application of coercive legislation, lowered evidentiary standards in practice, replacing legal criteria with subjective assessments, lack of independent oversight, absence of real accountability for public officials. These are issues at the core of the rule of law. To the Committee on Social Affairs. The failures described involve social services methods and practices, use of LVU instead of voluntary support under the Social Services Act, placements replacing resources, assistance, and support, misapplication of BBIC and the concept of the best interests of the child, insufficient support for families with children who have extensive needs. These are fundamentally social policy and child rights issues. When children are removed despite support being sufficient, both systems have failed. The starting point, LVU, is an emergency measure, not a standard tool. The LVU is among the most intrusive coercive laws available to the state. It is intended for exceptional situations where a child faces concrete, serious, and evidence-based danger, and where voluntary measures have failed or been refused. Yet, practice in many municipalities shows that LVU is applied based on concern rather than actual danger. Assessments replace evidence. BBIC is used as a decision-making tool rather than an assessment framework. The best interests of the child are reduced to subjective interpretation. Placements are used when resources are lacking. This is not what the law was designed for. This is not compatible with the principles of a state governed by law. Why this is not an opinion, but a structural problem. What is described here is not isolated mistakes. It is a structural pattern in which concepts such as deficient conditions, manifest risk, and the child's best interests are interpreted differently by different caseworkers. Support is replaced by coercion. Parental disabilities or a child's behavior are treated as risk factors in themselves. Family separation becomes normalized. When legal concepts are not applied strictly, legal certainty erodes. LVU then becomes a tool for managing difficulties rather than protecting children from genuine danger. This is exactly the development the legislator intended to prevent. Therefore, political responsibility is required, not more guidelines. As long as evidentiary standards are not clearly anchored, independent oversight is absent, and serious errors carry no consequences, the same patterns will continue, regardless of individual intentions. This responsibility cannot be placed solely on social workers or courts. It is a legislative and supervisory responsibility. Following this introduction is my full submission, unchanged, in which I outline how LVU is intended to be applied according to law and legislative history, what constitutes serious deficiencies and what does not, What manifest risk actually means. The documented risks associated with placements. How BBIC and the best interests of the child are misused in practice. Why support under the Social Services Act must be the primary rule. And which concrete reforms are required. Closing statement to both committees. This is not an attack on child protection. It is a demand that child protection be lawful, proportionate, and evidence-based. Children must be protected from real danger. They must not be protected from their families due to concern, lack of resources, or subjective interpretations. I expect both the Committee on Justice and the Committee on Social Affairs to treat this matter with the seriousness it deserves and to ensure that LVU is applied exactly as the law intends, no more, no less.